Today, we are so privileged to have two distinguished attorneys with us from Foulston Siefkin, Tara Eberline and Morgan Geffre. They will be speaking on pay transparency and legal requirements. Foulston Siefkin is the largest Kansas-based law firm serving businesses in corporate and business law, healthcare law, litigation, and employment law. Tara, a partner in charge of Foulston's Kansas City office, brings extensive expertise in employment defense. She assists clients in navigating very complex workplace challenges and defends them in state and federal courts. Recognized as the Employment Law Management Lawyer of the Year in the Kansas City, Kansas area by Best Lawyers in 2023, Tara is a trusted resource in making strategic and lawful employment decisions. Joining her is Morgan Geffre, an associate with Foulston's Employment and Labor Law Practice Group in Wichita. Morgan assists their clients with developing comprehensive employment policies, conducting workplace investigations, and representing them in discrimination claims. With the rapid evolution of pay transparency laws over the last few years and their continued development, understanding these changes is critical. Today, Tara and Morgan will provide valuable insights into the nuances of pay transparency, helping you to navigate the legal landscape and ensure compliance within your organizations. Please help me in joining Tara and Morgan to the stage.
This is the moment, tonight is the night. We'll fight till it's over, so we put our hands up like the ceiling can't hold us. Like the ceiling can't hold us. Can we go back? This is the moment, tonight is the night.
Well, good morning, everyone. Well, bright and early. I want to thank you guys for having us here today. We're really excited. So, as you get our introductions, I'm Morgan Geffre. I am in the Wichita office of our firm, and then I also have Tara Eberline here. And so we've kind of really delved into the pay transparency landscape nationwide to prepare for this presentation. And so we're excited to talk about some of the new trends. And so today we're going to talk about first just pay transparency, what it means, why is there this movement, and some of the pros and cons and employer considerations for making this move. We'll also talk about the legal requirements, both federally and on a state basis. We're going to try to cover kind of the most stringent states, which is interestingly, Colorado's one of those ones that has really strict requirements. So we're going to touch kind of heavily on Colorado, just so employers know that here's the most strict requirement. What do we want to do? And then we'll also finish up talking about pay audits and conducting those, and how to evaluate your pay practices and rectify those potential pay disparities. So first, I want to talk about the with pay transparency. Currently, who out there does your organization have any sort of policy on pay transparency? Do you post salary ranges for internal, external job postings? Okay, raise of hands, yes, we post it every time. What about some positions we post it, others not so much, maybe half the time? And who posts no pay salary information? So it's a pretty broad range, which definitely matches up with the nationwide trends. And so we can see here, this is the 2024, May 2024 numbers on the number of employers that would say that they themselves voluntarily disclose pay information on all job postings. And you can see that there's kind of an increase in the number of jobs that are voluntarily posting. Kansas is one of those states that doesn't require it, but yet here for us, we have
over 40% of employers are doing this. And so you can kind of see that there may be a little bit of a political trend in the more liberal states that require pay transparency, such as Colorado, that's had this new law. And so with that, the Colorado's got 81% of employers that are voluntarily now under this new requirement disclosing pay and those pay and salary ranges in job postings. And so the purpose of and the benefits of pay transparency are really quite broad. First, it facilitates pay equity among protected classes. And so what that means is you see this a lot in kind of the new move towards salary history bands. And so the idea is that inquiring into an applicant's salary history can perpetuate and compound this existing pay disparity. And so in the previous job for women, minorities, older workers, if you received lower compensation and your subsequent employer is now basing your future compensation on that prior number, it just kind of perpetuates those continued pay disparities. It also affects workers who may have entered the labor market during a recession, or workers that temporarily left the workplace due to caregiving responsibilities. And so that's kind of the first big movement, is the salary history bands. And then we have that the pay transparency simplifies identifying those pay disparities. And so this is kind of along the lines of the pay secrecy laws that prevent employers from prohibiting employees from talking about their pay. And so in those circumstances, when employees can't talk about what are you making, what am I making, in those situations, it's harder to identify those pay disparities when employees don't know what each other are making and what the policies and procedures are in a particular employer. Then pay transparency also enables employers to correct misinformation with the rise of Glassdoor and those other kind of third-party websites that now post, this is what the salary is at this employer. And those aren't always accurate. And so having greater pay transparency allows employers to kind of correct that misinformation. There's also a lot of studies recently that have shown that increased pay transparency increases employee trust and satisfaction, which reduces turnover and increases retention. So Indeed has released a couple of studies where it said that 80% of employees feel that being paid fairly is the top consideration when accepting a job. And the number one thing that they're looking at is pay. And if the pay is not listed in that job description, it really kind of changes what those potential applicants are looking at. And also, one of the big things that I think employers should focus on is that increased pay transparency truly narrows the candidate pool and is beneficial for both you as the person that is doing the recruiting and hiring, and then also from the employees as well. So now those candidates can select to apply because they know that salary is within their expected range, their skill sets, and it tracks their last salary. Or a candidate can say, that's not what I'm looking for, that's not the income that I'm interested in, and self-select out of the process. And so either way, the employer is going to benefit because neither side of the negotiation is going to waste time in this process. And so with both sides knowing the salary expectations up front, it really narrows the candidate pool for those considerations. And then also streamlines negotiations. There's a lot less wiggle room for employers and those applicants to negotiate a salary because the salary expectation is set out right there in the job description. But with increased pay transparency, we have to consider, is it right for our organization? And so we would encourage you to look at the demographics and your workforce culture. Historically, baby boomers are not interested in talking and sharing their compensation. It was taboo and an off-limit subject. You absolutely did not talk about your compensation and your salary, and you definitely didn't share it with your coworkers. But as our workforce has gotten younger, we have the Gen Xers and Busters that have moved a little bit more toward it. And then the Gen Y, millennials, and especially those Gen Z populations, they expect compensation to be listed right there at the top of the job description. And so really it's a deeper question than just what are the legal requirements, but what does our workforce look like, and what should we be considering? And so when we talk about pay transparency, that doesn't necessarily just mean we are posting our salary range in the job description. So there's going to be a range from individual transparency, where individual employees know their pay, and that's it. They might kind of have a general idea how their pay was set, but outside of that, they really don't have any idea what the pay and compensation structure and philosophy is of an employer. And then as you move farther to the right, there's more internal transparency, where there are potentially pay ranges or salary grades for specific job titles. But employees maybe generally know what the pay philosophy is internally, but job candidates aren't seeing that. And then we get a little bit bigger, where we've got external transparency, where now we're posting those pay ranges and those salaries for all jobs. But on the far end of full transparency, everyone knows what everyone's making. Everyone knows how everyone is compensated, how it's calculated, how increases and bonuses work, and on the far end is full transparency. And I'm not saying you should all go out and full transparency for everyone. So there's really a lot of factors to consider: the workforce, your own individual company culture, and the next big one, the legal requirements. And so I'm going to have Tara jump up here, and she's going to move on to the legal requirements.
So good morning, everyone. I'm Tara Eberline. So nice to get to spend a few minutes with you all this morning talking about the law, everybody's favorite topic for the beginning of the day. So we do want to spend some time thinking not just about sort of the cultural benefits or the reasons that we might want to think about pay transparency in our organizations with respect to what our employees might think about it. But obviously, we also want to start with the foundation of what does the law require of us, both from the perspective of what we're not allowed to do, what's prohibited, and also what we are required to do. Do you have the clicker?
Oh, I think it's still.
Did you leave it?
Yes.
Give me a moment.
Yeah. There we go.
We're ready to go. All right, sorry about that, everybody. So let's talk about the different types of pay transparency laws that are present right now throughout the country. Some of these are federal, a lot of these are state. What makes things really fun for us lawyers is when local jurisdictions throw their own laws in there, right? And so we not only have to worry about what the federal government is telling us and what our state governments are telling us, but also we have to think about individual jurisdictions where we might have employees living or working. So there are several that we want to talk about. I want to start with the Equal Pay Act, because the Equal Pay Act was sort of the first of the federal laws that was passed that addressed equal pay in the workplace. It actually was passed before Title VII, which I was surprised by when I discovered that, as I was learning about employment law. We think about Title VII as sort of being the foundation of our anti-discrimination laws. That's where our prohibition on discrimination or retaliation in the workplace exists. That was passed in 1964. The Equal Pay Act was passed the year before that, interestingly. So it was the first law that was passed at a federal level that said, we are going to pay men and women who are doing substantially equal work the same pay, right? That's what the law is going to expect. Now, the Equal Pay Act was an amendment to the Federal Labor Standards Act, the FLSA, and it has a lot of defined terms within it, each of which, in a lot of ways, frankly, narrow what is required under the Equal Pay Act, and it gives employers a little bit more discretion, a little bit more flexibility with respect to how we make decisions with respect to who we pay and how much we pay them. So what's important to keep in mind is this substantially equal language. That does not mean literally exactly equal, okay? And so there is some wiggle room with respect to how compensation decisions are made and when we're comparing position to position. So if we have two roles that maybe have a slightly different title but are doing essentially the same job, maybe it's different shifts, or maybe there's different titles because it's different departments, but they're doing the same work, that may be considered substantially equal under the Equal Pay Act, even if the title is not literally exactly the same. When we are thinking about what counts as substantially equal under the Equal Pay Act, the courts tell us, and what the statute tells us, is that we need to look at what kind of skill, what kind of effort, what kind of responsibility, and what are the working conditions that are applicable to that particular position as we're comparing from role to role. So we don't have to just say all of our entry-level people are getting paid, $50,000 period, and we're not going to consider anything else. It's not that constraining for employers. We do have more flexibility than that. But we do want to think about the things that are relevant, right, to our decision about how much we're going to pay an employee who's doing a particular job. So when we think about this equal skill that's required, that is probably a more complex analysis than just saying we need a bachelor's degree for this role, okay? So it's something more substantial than that. Do we need X number of years of experience? Do we need somebody who has specific experience in this particular industry? Do we need somebody who has a particular certification? Each of those things would apply to that question of substantially equal skill. One of the things that we can't consider, though, when we're making decisions about how we pay people and whether we're going to pay one candidate more than another candidate, is whether one candidate has perhaps an advanced degree in an area that's not relevant to the job. So I might be hiring for an entry-level employment attorney in our firm, and we have all of our candidates come in, and they all have JD degrees. They've all been to law school, but somebody else also has a PhD in forestry. Fantastic, interesting. It might make for a really interesting conversation about things, but that's probably not a good justification for me to pay that candidate more than the other candidates that are coming in who also have the required skill that's necessary for that role. Does that distinction make sense? Okay, so pay differentials are allowed under the Equal Pay Act when there are differences in the experience level of the person who's completing the work, the seniority of that person, the merit, their quantity or their quality of work. Other factors other than sex are permissible factors for us to consider when we're determining how much we're going to pay an employee. So again, we don't have to just say all of our level 1 IT managers are going to be at $50,000 and all of our level 2s are going to be $60,000. It can be more nuanced than that, but we need to be thinking about what are those factors that are important to us, and are we applying those in a way that's consistent and non-discriminatory. All right, so moving past the Equal Pay Act, the next federal level discrimination law that I want to talk about is Title VII. And I mentioned that earlier. It's, again, sort of our foundational anti-discrimination, anti-retaliation federal statute that exists within the law. Not only does it prohibit us from discriminating in the decisions that we make with respect to who we hire, who we promote, who we fire, how we treat people in the workplace, it also applies to the way that we pay people. And that's pretty important. And it allows employees or applicants to not only file a claim against an employer under the Equal Pay Act based on an allegation that they've been paid improperly, but they can also make that claim under Title VII at the same time. You might remember, it's been a few years ago now, I think it was 2009, there was an important Supreme Court case that came out, and the plaintiff in that case, her name was Lily Ledbetter. And she became kind of a famous figure for a window of time, at least in the world of kind of dorky employment lawyers like myself who are really interested in this kind of thing. And what the Supreme Court said in Lily Ledbetter's case was she made an Equal Pay Act type claim. She made an argument under Title VII that said, I'm being paid less because I'm female. And she said, that's not, I didn't just get a smaller raise 2 months ago that I'm mad about. In fact, I've been paid less every paycheck for a long period of time. And there's this history of unfair pay in this organization. And that's not fair. And what the Supreme Court said was, that may not be fair, but those decisions were made well more than 2 years ago, well outside of your statute of limitations. And I'm sorry, Lily, but you're too late to make that claim. And so Congress reacted. And Congress said, we don't think that's the way the law ought to work. And so they changed the law to say every paycheck that we pay an employee that is discriminatory is its own independent act of discrimination. And so what it enabled people like Lily Ledbetter to do is to say, even if a decision was made years ago where I started at an unfair place as compared to my male counterparts, and that has just perpetuated itself for years and years, every time I'm given a paycheck where I'm paid less than somebody who is in a substantially equal role to me, that's a new act of discrimination, and it's a new opportunity for an employee to make the claim. I say that because I want to remind you all that it's important for us to be keeping in mind that we need to keep current on this, and we need to be auditing our records and auditing our practices, and not just saying, well, heck, these people have worked here for 15 years, and I'm sure we did it right, when it started, and we've just been moving along, and everybody's gotten the same 3% raises, and so our raises have maybe been fair to everybody. But if that original decision years ago may have been discriminatory because it was based maybe on prior salary history, or it was based on some discriminatory decision that was made years ago, we're still responsible for that as organizations and as employers. So we need to stay on top of this and be thinking not just about our new people coming in, but about every one of our employees and ensuring that we're getting them paid properly. The OFCCP obviously governs federal contractors. That group has said that federal agencies are not permitted to use prior salary to justify compensation. There are also some of the circuit courts throughout the country that have reached that same conclusion, that when we're thinking about whether it's okay that Tara's paid in a different way than Jack, sometimes the defenses that employers have used over the years has been, well, that's because Jack was making 80 grand when he came in and Tara was making 60 grand when she came in. And we gave them both a $5,000 raise. And so, yeah, Tara makes less than Jack, but that's not because of our decision. That's because of what their prior salary history was, and it's what the market required of us, right? OFCCP, some of our circuit courts have said, no good, that doesn't work anymore. And so we as an organization don't get to sort of defend ourselves based on that prior salary history as being a legitimate reason to pay one candidate more than another candidate. That's tricky for employers, right? Because realistically, when we're trying to attract talent, Morgan mentioned compensation's a big deal, right? And you all wouldn't be here if compensation wasn't a big deal in your organizations. And so it is hard, I think, for employers to balance that struggle of, we need to be competitive in the marketplace. We know to get this great candidate, we're going to have to increase their salary from where they were before, but not doing that in a way that's discriminatory or that is essentially punishing an employee who either didn't negotiate quite as well on the front end or who has found themselves in a position where they're not making that same the same amount as that candidate who's coming in. By the way, in that situation, if you have one where you are needing to meet somebody where they are because we have a really hard to fill role, or we have a really fantastic candidate and we decide we need to increase comp and we're going to make an offer to them at a level that's higher than an incumbent that we have in a similar role, we can do that, but we need to make it right with our incumbent, right? We need to not just bring in that new person if they are truly substantially equal with respect to experience and all those other things we talked about. We just need to make it right and make sure that we're paying people equally. It's not that we can't increase that compensation, we just need to do it in a fair way. All right, so this I think is a really interesting chart. How many in the room is anybody responsible for EEO-1 reports in your organizations? We've got a few. Everybody loves them, right? It's your favorite time of year. So if you might have blocked this out from your sort of pre-COVID horrors and trauma, but there was a window there where not only did we have to do the EEO-1 reports that we've all become familiar with and know and love, but we also had to produce and provide a whole bunch of additional information. And it required us not only to provide information with respect to the gender of our workforce and the racial makeup and the demographic information for our workforce, but we also had to provide all of that information in these really narrow pay bands in all of these different job categories, right? So we had to say, how many mid-level managers do we have who are making $50,000? Are they male or are they female? Are they white? Are they black? Are they, all of these different categories. And we had to do that in our whole workplaces, and it was awful, right? Everybody was like, this is terrible, we can't do this. We only did it for about 2 years, and then it stopped. And it stopped, frankly, right around COVID. Well, guess what? The EEOC has told us they're bringing it back. So we'll see. We'll see if it happens or not. But the interesting thing is they have finally had an opportunity to consolidate all of that data, and they've produced and made public now the information that was gathered in those couple of years where we had to provide all of that awful information. And here's what it shows. you're not going to be shocked, right? This is one of many charts that you can see in the EEOC data. It's all public. If you just Google, for those of you who are interested in this, I do think it's really fascinating stuff. If you Google, 2018 EEO1, EEOC reports, something like that, you'll get into a database kind of hub where you can drill down and find all kinds of information. This chart shows the 2018 pay bands for by gender. And so what it shows, and this is all jobs mixed together. So it's, regardless of whether you were in retail or you were in banking or you were in law or anything else, this is all consolidated data in this particular chart. So at the very bottom there, the reason that one's biggest is because they had the most employees reported as making 19 grand or less. So that's like the biggest band that exists. But look at the gender side. So the blue side is men. Women is the orange side here. So 42% of the folks that were making 19 grand or under were men, almost 60% were women. And as we go up the chart, look at the way that changes. So of the highest pay band that was identified during that 2017-2018 time frame was $208,000 and over. 75% of the folks who were making $208,000 and over were men. Not shocking information, but also kind of cringy when you see it, right, on the chart. And we sort of know that this exists, and you hear about the pay gap, and we talk about that every year when the pay gap day comes up. But seeing it this way, I thought was really interesting. And again, if you go into this database, you can plug in your state and your industry and get this same chart narrowed down to just what you guys are doing. So it's really interesting and worthwhile to take a look at and to see where you are. I looked at Missouri. The Missouri numbers look a heck of a lot like these. The top band there in Missouri was 76% male, 24% female. The bottom band was 41% male to 59% female. So very similar to what's reflected in this particular area. Overall, what the data reflects is that the national median pay for men is one pay band above the national median pay for women. So we need to do better, right? I mean, that's not okay from my perspective, and I think we'd all agree that that's not okay, and there might be good reasons why some of these differentiations make sense and why they exist, but seeing it in black and white is a good reminder that we have room to grow in this area, and there is good suggestion out there or good data to suggest that these pay transparency changes that various states are exploring and working with may make some progress here from that perspective. So interesting stuff to take a look at. All right, this is just a reminder, frankly, of a few of the different kinds of ways that pay compensation or that compensation discrimination claims arise. And I won't go through all of them here, but the kinds of things that we do see sometimes are, let's say you do go through a process of determining what's market level for each of the roles within your organization. And the organization then decides, man, I think we can do better than market. I think we can pay a little bit less than market and still attract good candidates in these roles, but we think we're going to need to be above market in these roles. Oftentimes, what we see is that those that we're paying below market are those roles that have more minorities, that have more women, and that have less, underrepresented groups of folks within them, and that we're overpaying or we're paying above market to those kinds of positions that may be more traditionally predominated by men. So it's thinking about those kinds of decisions within our organization. Maintaining a neutral compensation policy, but that has an adverse impact on a particular group of people. We don't see this as often anymore, but an example here might be if there's some sort of benefit giving or boost given to a head of household. That is traditionally going to be the male member of the family. And so if we're giving some sort of benefit to head of household, that would be a discriminatory impact, perhaps, on women. Stereotyping, steering women and minorities towards lower paying positions. There was an OFCCP settlement that just occurred recently where what the OFCCP found was that females, Black workers, and Native American workers, security guards, this was a security guard company, they were taking those candidates and they were hiring them, but they were saying, why don't we put you in this particular role at this particular location? And those locations were, I think maybe lower security risk, or for whatever reason, they were being paid less than the folks who were working at other locations doing exactly the same job. And the OFCCP said, that's creating an adverse impact on some of the folks within your workplace. That was about a $2 million settlement that was just reached from that perspective. And then, of course, retaliation for opposing these kinds of practices is discriminatory, or is retaliatory, rather, is a violation of the law, and is not something that the law tolerates at this point. So, do you guys remember the show Mythbusters? It was on the Discovery Channel for a little while. It was these guys who would like take some scientific fact or theory that was out there, and then they'd try to establish whether it was true or not true, kind of thing. Part of our role, I think, as employment lawyers is to help sort of bust some of those myths that are out there with respect to what the law is. I remember growing up believing that if you lived with someone for 7 years, you were automatically married to them. And I was like, oh, I need to make sure I'm careful with, my roommates. Turns out that's a myth. Don't worry. But there are some myths that are out there, I think, that are perhaps maybe a little more realistic than what my elementary, fears were. So true or false, an employee may prohibit employees from discussing or disclosing compensation with other employees. Who says that's true? We can prohibit employees from discussing comp. Yeah, good job. You guys are listening really well. So we cannot do that. There are, in fact, several different kind of overlapping laws that talk about pay secrecy, and the law really has changed and evolved in this way. I think 20 years ago, it was pretty common to see employee handbooks that said, you shall not talk about your compensation with other employees. We saw that a lot. And the National Labor Relations Act says, look, compensation is clearly a term and condition of employment. It's clearly a topic that employees need to be able to talk about and engage in concerted activity. And so discussions about compensation are protected under the National Labor Relations Act. So if you are a private employer, you're governed by the NLRA, almost certainly. And so we cannot have a policy that says you can't talk to your coworkers about what you're getting paid. We shouldn't have that policy anyway, but the law prohibits it, whether we want to do it or not. Federal contractors are prohibited from discriminating against employees or job applicants for discussing wages. Same kind of idea, just applied at the federal level. The note there, I think, is important. Some of us work in fact, maybe all of us work in the world of compensation, and many of us probably have access to lots of information about what other people make within the organization. These laws don't say, our new comp assistant who we hire is allowed to just post on their blog everybody's compensation and start to just share with the world what we're doing. That's not what the laws exist to protect, and it's not what is protected under the law. So what we're talking about is the protection as employees are allowed to talk about their own compensation. My mom worked for a company in the education sphere, but she was in more or less a sales position, and she had a commission piece to her job. And she'd been there quite a while, and they did shake up sort of what they were incentivizing from a commission standpoint here and there, and so it might be, you get X% on this product and you get Y% on that product. Well, the organization was expanding, they hired new people, and so she got to sit down with one of the new hires who was gonna do the same role as her in the same region as her, and they got to talking through the process of training and whatever else, and she learned he was being incentivized to sell different products than what she was, and the result, when they did the math, was that they were paid $30,000 or $40,000 differently over the course of the year to sell exactly the same stuff to exactly the same clients. My mom has an employment lawyer for a daughter, and so she said to me, "Is this okay?" And I didn't represent her. I was not officially her lawyer. I was just her daughter in the moment. But I said, "I don't think that's okay," and she didn't either. And so she reached out to her HR department on her own, and she said, "Look, we are doing the same job in the same place with the same clients, and he made $40,000 more than I did last year. That can't be okay, right?" And it was really interesting, and they kind of worked through it, and ultimately they made it right, not just with respect to her, but with respect to sort of her whole class of sales folks. That they said, yeah, we probably shouldn't do that. We probably shouldn't incentivize people differently to do the same work, in the same region. So pretty interesting way. And frankly, had they not had that conversation, she would have had no idea, right? And would have left a bunch of money on the table. So there are, I think, good reasons to do this. There are struggles with it on the employer side. We don't really like the drama that's associated with people saying, well, wait a second, why is he making a little more than I am? Or why am I making a little less than this other person? But I think there are good policy reasons to move that direction. All right, so we talked about a bunch of laws that say things that we can't do. We can't discriminate. We have to treat people similarly. All of these kinds of things. The last one I want to talk about before we talk about job postings is salary history bans. And this, I mentioned it earlier with respect to the OFCCP. This has been sort of a developing area of the law. And what these laws are saying is that we are not going to be allowed to talk to employees, talk to applicants rather, about what their salary was before they came. And it's sort of taking off the table that argument, well, gosh, he was making $80,000 before and she was making $60,000 before. If we don't know, we can't rely on that to make our decisions about how we're going to pay people, right? So what these salary history bans say is that you cannot ask applicants about their past salary, or you can't rely on it. Sometimes people are going to tell you that information whether you ask for it or not, but we need to make a decision as an employer about what we're going to pay people based on the factors that are relevant, their experience, their qualifications for the job, those kinds of decisions rather than what they were making before. We can ask applicants under most of these laws, what are your expectations, compensation expectations for a role? We don't want to waste our time, right? And I think sometimes, with all due respect to our legislators, they don't live in the world that you all live in, right? And some of these things sound really great in theory, but at the same time, you're like, well, gosh, if I am spending hours working with a candidate who's currently making $200,000 and I'm recruiting for a job that makes $60,000, we are both wasting our time, right? And if I can't ask that question, how do I know whether we're wasting our time or not? It is okay under most of these statutes to say, or these state laws to say, what are your expectations for this role? It's also okay for us to say, here's our range, and we'll talk about those job posting requirements or options that we have from that perspective. But what we're not allowed to say is, what are you making right now? And then depend on that or rely on that to make our decisions about what we're going to do next. So I did a little bit of research before I came, because this changes all the time. As I said, the challenge of these laws is that they're happening on a state-by-state level, and so they change all the time, and none of them are exactly the same as the next one. 22 states now have statewide bans on use of salary history. So that is, we're not quite at half of the country, but we're getting pretty close. Here's some little interesting tidbit for you. 2 states, Michigan and Wisconsin, have a ban on bans on salary. Think that one through. They say local governments in Michigan and local governments in Wisconsin can't ban employers from asking about salary. It's a ban on a ban. So they've gone the opposite direction. I don't know. If you have employees who are working in both places, it is still okay to not ask. None of these states say you must ask what people's prior salary was, but there are these couple states that are sort of outliers that are saying we're not going to legislate what employers can ask about. So a little more flexibility in those couple of states, but things vary kind of from state to state. Those of you who are working in a lot of places, it's challenging. We'll talk through, and Morgan's going to talk next about these state job posting requirements and how they vary a little bit from place to place. One approach that some of our clients take is to do sort of the most conservative thing, and conservative is not even the right word, but sort of the thing that's allowed everywhere, right? So we can take the approach of, look, if we're not allowed to ask about salary in Colorado, we're not going to ask about it any place in the country. If we're not allowed to, consider whatever factor in one of our states, we're not going to do it any place. If we're required to post our job, our salary ranges in one state, we're going to post them in all states. That's a safe way to do it. That's a way that gives you some consistency within your organization, so you're not thinking, what if we're in Wisconsin, what if we're in Michigan kind of situation. You can do that. You don't have to do it, but depending on how complex and how broad in scope your organization is, that's one approach that some of our clients have taken. We also have clients who have handbook policies and other policies that say, while in Michigan we do this, and while in Kansas we do that, and we can do both of those things. So Morgan, let's talk about state job posting requirements. It's the green button, in case you're wondering.
And so as Tara was talking about, it's kind of this patchwork, and it is really difficult for employers to kind of navigate that situation. And so we have this chart that kind of shows where we're at on these new pay transparency laws that specifically require salary ranges and job postings. And so you can see there's kind of, I think the total number that as of January 1, 2025 should be about 13 states that require salary ranges and job postings. And some of those laws require a lot more, some are bare minimum. But you can see that it is difficult for employers to operate in numerous states. And then you add on top of it that we have, New York City, Cincinnati, Jersey City, little individual municipalities that are having their separate requirements. And so when we talk about the requirements in job postings, I am going to talk about it on kind of the most stringent level. If you want to comply everywhere in the United States, here's kind of what you need to do. And so obviously you can kind of pause and look at what state individually do each of your employees operate, and then it's not just where are we physically located, but it's where do we have remote employees. That's going to be included as well. So when we talk about job postings, what is a job posting? You would think that we've got our Indeed job posting, it's pretty clear and obvious, but it may not be exactly obvious what is a job posting in some of those specific states. So we're going to look at any notification that employer has that a specific job is available or they are accepting applications for specific position. So generally, all advertisements are going to be covered, whether it's a newspaper advertisement, a printed flyer, or an email that's sent to a pool of applicants. The state of Washington has explicitly provided an example that if you have an electronic reader outside of your place of business that says "Help Wanted Server," it needs to include food handler certification needed, offering $24 to $26 per hour, medical benefits, 70 hours vacation, $500 sign-on bonus. That all has to be in that electronic reader ad because that's a job posting. And so it's clear, I think, in some circumstances what isn't a job posting. The help wanted sign, that general social media post that says, "We're hiring, period." Or generic break room signs of, remember to check what promotions are available. And so, but it's not going to be super obvious sometimes what is a job posting when you kind of have those non-traditional means, such as the electronic reader outside of your business. But remember, there are no federal laws on this. It's really just going to be the patchwork of when pay transparency is required in the job posting. And so a lot of employers have kind of asked and questioned, well, what about, my Indeed and my LinkedIn post? Or if sometimes you get those third parties that pick up your job description and your job posting and they repackage it and they post it themselves. Am I still going to be responsible if Indeed kind of leaves out that salary range that I've previously included? And so no. You will not be liable in those situations where a third party is taking and reposting your post. And they've also clarified that LinkedIn and Indeed will not be responsible if you have posted incorrectly without the job posting as well. But it's really kind of important to look at what is job posting on the basic level. But when we talk about what's required in that job posting, what does that mean? So it's generally going to be the rate of pay or a pay or salary range. And then there's also the added requirement to include benefits. And so we'll talk about more about that. And then Colorado, oh dear, Colorado has these two extra requirements that you have to include in your job posting, how to apply in the application deadline, and there's this big requirement for notification of job opportunities. And so I will touch on that a little bit, but those kind of two extra requirements are pretty specific to Colorado. And so pay ranges, what are they? How do we calculate it? What's it look like? And so when we talk about that pay or salary range, it must be the minimum or maximum pay the employer reasonably or in good faith expects to pay a successful applicant. So typically, good faith means that the employer would be willing and truly believes that they would pay a successful applicant. And so Ranges are compliant if they include the lowest to the highest range that they actually may offer, and it will depend on the specific jobs, the qualifications, budget and finances, the experience and education level, and what your current employees are being paid for that role. And so you can't just kind of look prospectively, you have to look at what your current internal employees are being paid to make sure that salary range is consistent. And so ranges cannot lack a top or a bottom. You cannot just say that it's going to be 30,000 plus. No more than 60,000. And so it also has to be true and honest and in good faith. So you can't simply post 30,000 to 100,000 for our janitor that we expect to pay 30,000 and 30,000 to 100,000 to our accountant that we expect to pay closer to 100,000. And so it's got to be that genuine anticipation. And so there's also the kind of consideration of starting ranges in comparison to kind of the general range. And so it's possible that for some roles, we might want someone more experienced specifically, but it might also be where some employers have for the first year or for this first kind of temporary probationary period, this will be the compensation and then you will automatically get bumped up. Washington has said you have to include that. If you've got kind of a set time period where you are going to start at a starting range and then you're going to be automatically bumped up, you have to include that. And then there's also kind of those non-traditionally, you're not making a flat $13 an hour and you're not making a kind of a salary, that those fixed rate, commission, piece rate, you have to include how you reasonably plan on calculating that. So there's kind of examples of what's the expectation, both on your end and on their end. And importantly, can an employer end up going outside of that range? Yes, but there are kind of limited circumstances. And so all of the states that have pay transparency laws generally have kind of Q&As. And so New York has said, I interviewed an applicant with a master's degree and I'd like to hire them. Generally, when we thought about the pay range, we thought of somebody with a bachelor's degree, but now can I increase the compensation to match their advanced degree? Yes, in that circumstance, you can, but if you receive an application that exceeds those qualifications, then that kind of initial job posting, you can pay them more. Or like Washington includes the hypothetical that an applicant discloses a competing job offer during the hiring process, and the employer wants to now offer a higher salary to match that. Can you do that? And so Washington has said that yes, you may match or exceed a competing job offer during the hiring process, so long as the pay difference is not determined on the basis of gender, race, or any other protected classification. So if that justifiable reason for wanting to bump up outside of the salary range is discriminatory, we will obviously never be able to do that. But it really kind of is a sticky situation for employers to really think in advance on what is the salary range for this job? How are we calculating it? Are we truly going to stand behind and believe that this is what we intend to pay for this range? And so a lot more decisions for employers and for those hiring managers specifically. And then outside of just the salary ranges, you've got to have benefits. And so generally, if you've got an employer where there's going to be tips or bonuses or commissions, you have to include a general description of what that means. And so if you've got an employee that may expect to make some tips, you could say their base salary or base pay $15 an hour plus tips. You could say $15 an hour plus an estimated $5 to $10 in tips. You cannot say $25 an hour with tips and leave out the fact that they're making $15 as their base pay. And outside of just those tips and bonuses, you also have to include, we will provide health care. We will provide some form of retirement benefits. We do offer paid time off and those other tax reportable benefits, but you don't need to necessarily say that we give a discounted gym membership in that job posting. And a lot of states also kind of include that disclaimer that you can include a QR code or a link to more specifics, but in that base job description, you have to include a general summary. New York specifically doesn't require any the inclusion of benefits, but Washington, on the other hand, is really specific. You can't just do the general, we offer retirement benefits. You have to specifically say if it's a 401k, an employer-funded retirement plan, deferred compensation, or whatever other kind of plan it is. You can't just simply say we offer paid time off. You have to say we offer 12 days a year, we offer 8 hours per month, as well as holidays and paid sick leave if it extends past what is the mandatory Washington requirement. So again, it's really kind of a patchwork, but if you want to comply everywhere, those benefits in your job description has to be really specific. And so when we talk about that how to apply and when requirement in Colorado, which a lot of job descriptions will likely probably include some explanation of here's how to apply, give us your resume, drop it off, here's a link on an online application. But there's an option for an evergreen, we're always hiring in this role. There's a lot of turnover, so it's an evergreen position. It's acceptable to say we will accept applications on an ongoing basis, but open until filled is not going to be okay. And so you have to offer a good faith deadline that we will keep this job posting open for 3 weeks. We will keep this job posting open until October 31st. And if you're going to say open for 3 weeks, make sure you include a date that you're posting that, because otherwise that 3-week timeline is kind of hard to calculate. And importantly, once that decision is made on hiring, remove that job posting. But obviously, employers can periodically update. And if they do not have any qualified candidates within 3 weeks, you can extend that deadline. But if you're a week into the process and you decide, oh, we found our candidate, you importantly cannot close the applications early. And so that's kind of a tricky thing for Colorado employers to consider. And then also for Colorado employers is this notification of job opportunities. And so this is kind of a big consideration, is that Colorado puts a lot of emphasis on your internal existing employees and not just simply on kind of new employees that are coming in. So they're saying that all existing employees need to receive notification when a job opening occurs. And so there's kind of a question of what always is a job opening. That may not be clear. And so Colorado has painstakingly defined a bunch of different categories, then said it's not a job opportunity if it's a career progression, which is like a regular or automatic. You are IT1 for a year and then you become IT2. If it's an automatic that it doesn't require any sort of kind of subjective considerations on behalf of a supervisor, in that circumstance, you wouldn't have to post that there is an opening for IT2 because it's not really an opening, it's just a career progression. Same with kind of career development. If that IT1 starts kind of taking on other roles and other considerations where it kind of changes their job description and their job title, you're able to update that without it be considered an upcoming job opportunity. And then there's this other kind of consideration that if the job is to be performed out of state, There's no Colorado physical location, and in Colorado you have less than 15 employees. You do not have to give a job notification for that. And then there's also interim or temporary positions. If it's less than 9 months is going to be the standard for that. And then they're so gracious to say that you can hire a confidential replacement without having to, if you haven't terminated the employee and you would like to rehire their replacement before terminating them, you do not have to post that we are hiring for Morgan's job. Please come apply for Morgan's job. Morgan doesn't know she's being fired yet, but come apply for her job. And so that's really quite nice on behalf of Colorado to add that kind of exception. And then Colorado also clarifies that you can post on an intranet, here are job openings, so that you can see that and apply. And again, on this kind of internal emphasis that Colorado has, that there's also the consideration that some states allow existing employees to ask about their pay range and their pay scale. And so it's important that when you're doing those pay ranges, it's not just for new incoming employees, it's also for all of your existing employees too, because now you might have employees asking questions, what is my pay range? Where do I individually fall? And then all of those laws have these important anti-retaliation provisions that say if an employee is questioning their pay, where they fall in the pay, why, you cannot discriminate or retaliate or take any sort of adverse action against the employee on that basis. And so again, there's a reminder that employees are not entitled to pay of other employees, and they're not entitled to the compensation on pay scales of jobs not yet posted. And then Colorado also has this requirement of notification of selection. Once you've selected an employee, you are required to give employees notification of who has been hired. Within 30 days, all of the employees that this new individual employee is going to be working with have to be informed that you are getting a new coworker. And it's kind of a formal process, but it requires a notice that Morgan has been hired or promoted, and here was her prior role, here is her job title, and if you are interested in future job opportunities, here's where you should pay attention, basically. And so it's really kind of a formal process in Colorado, but it really puts a lot of emphasis on internal employees. And there is also a very kind exception that employees can opt out of having their notification of the fact that they were hired or promoted. You don't always, some employees are very quiet and don't need everyone knowing their business. And so, but the disclosure exception is only if it is for their health, their safety, that you can opt out of it. So I think in that circumstance, it kind of considers employees that may be a victim of domestic violence or those sort of circumstances where they keep a low profile for health and safety reasons related to that. But still, the employer must provide notice, this job has been filled, here's how you apply. So really, it's quite detailed requirements there in Colorado. But again, what happens? We've already got a candidate in mind that we want to hire for this position. Employers in those situations, they do not need to post externally, but still Colorado requires this job opportunity requirement. An employer could identify recommended candidates and still allow employees time to apply, which Colorado has proposed this job opportunity notice that, we want to hire John Doe. This is who we recommend for the position. This is his proposed salary range, and here's how you can apply. But realistically, it's very, very awkward. So, Colorado's law may not be where that's most stringent state comparison that employers want to consider. But just so you know, this is what Colorado considers the most pay transparent they can be. And so there's this really tricky consideration for these multi-state employers on where in the world, how am I supposed to comply, what do I comply with? And so generally, employers must comply with a state's pay transparency laws if they have one employee in the state, even if it's a remote employee, and the position may be filled within the state either by someone physically working there or if they're working there remotely. And so if you have remote employees scattered throughout the United States, you are now obligated to comply with those states' pay transparency laws, even though you do not have a physical location. New York also requires, even if you do not work in the state of New York, if you are reporting to a supervisor, office, or work site in the state of New York, you are required to include those job posting requirements. And so there's also this other important disclaimer in all of those states that say you cannot simply say, we will not hire Colorado employees to avoid complying with all of those Colorado requirements. And so you can't simply include a carve out in your job applications. And so a lot of times the pay range may be different for a job in Kansas in comparison to a job in Colorado. The job markets are different. And so most states say that you have to include the reasonably expected pay range for Colorado employees, for New York employees, for wherever they're physically located, if those pay ranges and salary ranges are going to be so substantially different from one state to the next. And when it comes to that notification of job opportunities for multi-state employers, Colorado has said that you don't need to notify your non-Colorado employees if it's a Colorado-specific job. And then if it's a job that is being performed outside of Colorado and there's less than 15 employees in Colorado, you also do not have to provide that notification of job opportunities. So those pay transparency laws go a little bit further than just posting that pay range, especially Colorado, so a little tricky. But remember, pay range, and got to be good faith, and then also you have to include those benefits as well. So now we're going to transfer over to Tara to jump on pay equity audits.
Colorado, man, that's a lot going on there. So let's talk about pay equity audits. This is an important tool in your toolbox with respect to ensuring compliance with all of these laws, particularly with respect to the equal pay laws that exist. So we want to talk about a number of things. And let me start with just a couple of overview or general comments for you all. Our recommendation most of the time is that it is worth the time and the expense for many employers to work with outside counsel when you're conducting a pay audit. And that's not just sort of self-preservation to make sure lawyers have work to do. It's really because this beautiful thing called attorney-client privilege. And when you work with counsel and you come to your lawyer, your employment lawyer, and you say, we need to take a look at our comp system and how we're paying people either across the board or in this particular job category, and we're worried about it. If you use your attorney then to consult with an outside consultant, or sometimes the attorneys will do the pay audits themselves. Sometimes they'll work with an outside consultant. There are really fantastic ones out there. BalancedComp might come to mind. Work with counsel, work with BalancedComp or another pay audit organization like BalancedComp, so that when you get that data back, when you get your report that says, here's how we're paying our folks, and here's the risk factors we might have, or here's the sort of red flags, we can work together within the realm of attorney-client privilege to try to make some corrections and to try to figure out what's going to be our strategy to make this right. And then the hope and the goal is that if down the road we end up with a claim from somebody saying, wait a second, you paid me in a discriminatory way, the first discovery request you get in those lawsuits are, tell me all of the audits you've done, tell me all your reports from your audits, tell me all your emails and your correspondence with respect to compensation, how you decided how much you were going to pay Tara versus Morgan. And if you've done that all within the bounds of attorney-client privilege, we've at least got an argument that doesn't need to be produced, okay? And so that's a strong recommendation that we make. It doesn't make sense in all circumstances. There's certainly, circumstances where you don't maybe need that protection of attorney-client privilege, but I don't think it ever hurts. Other than, of course, there's some additional expense involved in doing it that way. But think through that part. If you're going back to your employer and saying, look, we think, it's been a long time since we've really done an audit. I think we ought to do it. You might think about working with your counsel to do that within that protection of attorney-client and work product privilege. When we're doing these pay audits, again, what we want to do is compare apples to apples, right? So we need to think about who's performing the same or significantly similar work and really give that some thought, not just necessarily look at job titles, but also think about what the responsibilities and the duties are of our employees so that when we are doing that analysis, that the analysis is helpful to us because we really are comparing apples to apples. That statistical analysis, and I'll talk through this on another slide as well, but gender, of course, comes to mind. We've been talking a lot about gender today, but that's not the only consideration that we need to be thinking about when we do an audit. And so it's not just a question of are we paying our men and our women substantially equally for substantially equal work, but are we paying our workers of color the same as we're paying our white workers? Are we paying our older workers substantially equal to our younger workers? Each of those protected classifications, of course, are protected by Title VII, as we talked about. So we want to be thinking not just from a gender perspective, but with respect to each of those protected classifications. And then again, we'll talk about what steps do we take if we get to the end of that pay audit and we have kind of an moment where we think there's something that we need to work on. So think about scope. When you're thinking about are we going to do an audit, what might that look like? What's the appropriate scope for your organization? And that's going to depend on what you've done historically. If you've never done one, if you've just sort of grown organically as an organization and we've never really sat down and completed an audit, you might need to sort of bite the bullet and do the whole scale deal and look at it on a broader scale. If you do these on occasion, you might think about getting into some sort of a rhythm so that every couple of years we're looking at a different department or a different team, or maybe comparing across teams if there's an appropriate way to do that, but not necessarily needing to do the whole deal every time you conduct an audit. If we're needing to make decisions about who we're going to audit or what departments, think about what might be more high risk. And when I think about that, the things that come to mind for me are, do we have departments or organizations or areas of our organization where we tend to have lots of one gender of workers? So we have lots of women and just a few men, or we have lots of younger employees and just a few older employees. Those kinds of situations are the ones where we might end up seeing that there's a disparity there inadvertently because we tend to hire in a particular class, and then there's somebody that might not fit within that class. And then again, and your partner in the audit, the consultant that you hire, will work with you on all of this. They have the tools to do this really, really well. But we want to make sure that we're using a uniform period of time so that, again, we're comparing apples to apples and that we get good data that comes out of that report. So the audit itself, we've talked about ensuring that that is privileged and confidential to the extent that that's important to you and your organization, that's an important thing to do. Your partner, the consultant that you use, will conduct that statistical analysis for you. That's at least my recommendation. There are some of you in the room probably who are pretty skilled at this and who have done it before and can do it yourself, and that's fantastic. For most of us, it's the better approach is to use an outside organization to do it. And even if you are trained and have done these internally for your own organizations, my recommendation is that occasionally, every few years, you use an outside person to do it as well, just as a check on yourself and as an additional protection for your organization, that we don't sort of get into a process of groupthink or handling them the same way. It's just good to get a little bit different perspective each time that we conduct one of these audits. All right, evaluating our findings. As I said, if we conduct an audit and we get to the end and we find out that we have more than a 2% difference in compensation for folks who are doing substantially equal work, the OFCCP would say that's a significant difference. That's something that they would want to look at. So $2,000 or 2% is what they've said. Those are not magic numbers necessarily under Title VII or the Equal Pay Act, but that's just sort of a guidance for you to think, okay, this is probably something that we need to think about. Is there a reason that we have folks who are more than 2% or more than a couple $1,000s apart from one another who are doing the same kind of work? And then let's look at what those reasons are. Is it about experience? Is it about education? Is it about quality of work? All of those are legitimate, justifiable reasons. It's okay to pay people different amounts if they are doing different work for you or doing different quality of work. Or have been with us for different periods of time. So don't necessarily be spooked by that initial reaction that you get when you get your report back. But spend some time really thinking about what are the reasons that we have the differences that we do. So one example, we have 2 employees with the same job title. One's a black female, she's making $46,000. One's a white female, she's making $40,000. That's over the 2,000, it's over the 2%. It might be a red flag. What's going on here? Why is the one of these gals making more money than the other gal? If one of those people has worked for our organization for 25 years and the other one's been here for 2 years, easy answer, right? And that's okay. And that's not a situation where we'd have to say, we better raise up the white female to be at the same level as the African-American employee. We just need to have a reason, right? And in our report and in our analysis there, we need to be able to justify why that decision was made. All right, so let's talk about remedying pay disparities. If we do get to the end of that analysis and we've looked at our numbers, we've compared apples to apples, we've looked at experience, we've looked at qualifications, we've looked at how well the employees are doing, and we still have a difference, then what? What the law says is that our obligation as an employer is to raise up the person who is at the lower compensation level to be equal to the person who's at the higher compensation level. We are not under the law allowed to reduce the compensation of the higher paid person to be equal to the person that's the lower paid person, okay? So if we get to the end of the road and we say we do need to make some adjustments here, we always need to adjust up, we can't adjust down. That's important, I think, to keep in mind. But then how do you do that, right? And many of you maybe have been in these situations where we've had to make adjustments, whether it's because of an equal pay issue or because we've decided that we've maybe classified somebody improperly under the Fair Labor Standards Act and we need to move them from salary to hourly, or there's other reasons why we sometimes need to make changes, right, to how we pay people. And that communication is challenging. If we go to an employee and we say, we just completed our first ever audit, and gosh, it didn't go great. We found out some things we didn't think were real good. And guess what? You're going to get a $10,000 raise. Congratulations. Have a nice day. They might be happy for a moment, and then they're going to go home and say, I wonder how long I've been not paid those $10,000 that I should have been paid. And I wonder about my coworkers. And I wonder if that's actually illegal. And I wonder if they've been doing something wrong for a long time. And I wonder if I'm really entitled to something over more than $10,000, right? Those are all the questions that are going to start to come from an employee who's given the good news, that they're getting a raise. Work with counsel on these and think through your strategy with respect to when and how we make these changes. There is certainly the safest, the most legally compliant option. What the EEOC would tell you to do is go back 2 years, pay them everything that they've been owed for 2 years prior and double that. That's the liquidated damages part that they'd be entitled to if they sued you for it. So double the amount that we didn't pay them over the last 2 years. That makes them whole, and then go forward and do that with everybody that you made a mistake with. You could certainly do that. Some organizations do it. Employees, I'm sure would be very grateful for it. That's the sort of most legally compliant method. I would never advise you to do something less than the most legally compliant method. However, if you were to talk to an employment lawyer under attorney-client privilege, they might talk to you about alternatives that you have. And so those kinds of alternatives might be things like, let's make this change when we make our annual salary changes rather than making it midstream, right? So it's not this like blaring bright light that we're making this change because of an audit finding. Or let's make a bunch of changes at the same time where we can talk about how we've changed our philosophy with respect to compensation and give some information about that. That might sit a little bit different with your workforce, and it might enable us to make a change moving forward. A lot of times, by the way, we might conclude at the end of an audit or at the end of a process that we've not done anything illegal, but we're going to make some adjustments to be safe or because we think it's the right thing to do. And in those circumstances, it might be very appropriate for an organization or employer to say, we don't think you're owed 2 years of back wages doubled, right? But we do think we're going to make this change for you moving forward. And so my point is, work within the bounds of attorney-client privilege, have some conversations about that and think about it strategically so that we can get people paid the right way, but we can do it hopefully in a way that as an organization we're not just giving ourselves a big spotlight on ourselves to be audited by the Department of Labor or to have an uprising within our organization of what's going on and how long has this been going on. Does that all make sense? All right, very good. Couple just key takeaways here as we finish things out, and we'll have a few minutes for questions yet, if anybody has any. I think we've talked about a lot of these things, and so they're just, again, some reminders here. Engaging in that salary benchmarking and pay range process, working with BalancedComp or with organizations like BalancedComp to think through how do we decide how we're going to pay people and what are the factors that are important to us, and do we have ranges that we're comfortable with, are really important processes that are going to help us to defend our decisions down the road and to ensure that we are paying people properly. No more pay secrecy policies, no more practices from that perspective. We're not going to penalize people. We're not going to discipline anybody or terminate anybody for talking about their compensation anymore. Reliance on salary history is, the trend is certainly going away from being able to rely on that as an organization for being a reason that we have decided to compensate people the way that we have. And so moving away from that, even if you're in a state where it's not officially banned, I think is the way of the future and is something that you might think about doing affirmatively before you're required to do it. We talked a lot about salary ranges and job announcements, the benefits of doing that, the places where it's required, but also for those places within the country where it's not necessarily required, there may be some advantage there in narrowing your pool appropriately on the front end and giving people good expectations with respect to what they might find in a given role rather than waiting for the end. And then we talked about that notification of open positions requirements that exist in some of our states moving forward. And Morgan will probably join me up here. Just these last couple, I'll have her talk through, and then we'll be happy to answer any questions you guys have.
Yeah, so those last couple of practical steps that the employers can take are to make sure your job descriptions are current and reflect the existing position qualifications, skills, and duties. And so you want your job descriptions to match those salary ranges that you decide to set. And so it's important from an employment law perspective to keep those job descriptions up to date for the ADA reasonable accommodation considerations, but also to make sure that those are accurate with regard to their compensation as well. And then the other big thing is to make sure that your supervisors and your managers are up to date on the requirements as well, their legal considerations, the pay disclosure laws, and to know if we have a situation where we we're making a change, there needs to be a ton of communication with managers and supervisors on how to handle these conversations and to how to navigate those situations, and especially with regard to documentation. So in situations where managers are going to deviate from the salary range that's posted, in situations where there is negotiation, there needs to be clear documentation from those hiring managers on why they're making that decision and where that's coming from. And then finally, making sure that you're staying up to date in all the states that you operate, which can be tricky, and then also those municipalities as well. And so most of the laws are going to go into effect January 1 of every year. And so every fall, it might not hurt to kind of spend a couple of hours doing your Google searches and everywhere that you operate to confirm what changes there are. Some employers choose to set up kind of a Google alert notification for Kansas and pay transparency. So anytime there's kind of a new article or update on pay transparency in Kansas, you can get that notification. And so those are just kind of our practical steps, but now we are happy to move forward with questions. If you have questions, I know we threw a lot at you for sure.
I'll confess we can see almost nothing with the lights coming this way, so you might have hands up and we just wouldn't know, but feel free to shout out a question if you have one. Yes, right up front.
Thank you. My question is, I heard two things, and I was trying to understand what's legally required and then what's just the right thing to do. So the point I think made was for under equal pay. If you have a pool of candidates or employees doing a similar role, and you go to hire someone and markets move faster, a lot faster than, say, longer tenured employees in that role. Can you just help me distinguish between what's legally required versus, if you want to keep your employees, you should level up?
Yeah, I think that's a really good question, and it's and there's not a super clear answer under the law. What I would say is that, both the Equal Pay Act and under Title VII, we are permitted to consider as reasons to pay people differently tenure in the role. And so if somebody is being paid more because they've been with us longer, that's probably easier to justify than the opposite, which I think is what you're speaking to, which is our new hire demands more because the market has changed, and it's sort of the incumbency penalty, right? Where if you stay in a job for a while, in some ways maybe you end up getting paid less because you don't get that benefit of saying, well, the market's changed, and so I need this expectation of additional. I think you would need to be able to establish that. If you had a claim from a current employee who said, wait a second, I'm an accountant one, and I'm getting paid 80 grand, and this accountant one who just got hired after me, worked here less, has less experience than I do, or maybe equal experience than I do, is now being paid 85. That's not fair. I think there's an argument to be made there by your current employee that there is, that's a violation of the law. Now, they'd have to establish that that's a violation of the law because you're treating them differently on the basis of gender or sex, right? Or some other protected classification. And so your defense is going to be, look, the market demand is different. I think that can be hard for an employer to make that pitch if that's truly the only distinguishing factor between the two. So I think it's challenging for employers. I think the safe approach is to make that person whole if we really don't have another distinguishing factor between the two of them. If there is an education difference, if there's an experience difference, if there's other things we can speak to, that's going to be easier. Market demand is not sort of one of those things that's listed in the statute as sort of a legitimate ground for treating people differently. And I frankly think, an argument could be made that it's sort of the Lilly Ledbetter argument that we talked about earlier, where it's, I'm being paid differently or paid less for something that happened before. But if that's a sort of a new wrong every time, I think there's an argument that could be made by your current employee that they really ought to be made whole if we're paying somebody with the same qualifications to do the same job that they're doing, and they just did a better job negotiating or came in at a time when that range was a little bit higher. Not a great answer, I understand that, and I wish I had a better one for you, but I think it's a bit of a gray area in the law. And is one that you'd sort of have to argue from a fact standpoint.
Yeah, on its face, it seems neutral, but it's also
It does.
pretty cruddy, right?
Yeah.
Experience standpoint, and that's what I was curious about.
Yeah, I think that's a really good way to describe it. It is a neutral, non-discriminatory reason to make that difference, but it's a difficult one, and it's not one that's identified specifically in the statute. Other questions?
Over here, yeah. So speaking of Lilly Ledbetter, we're looking at our next acquisition, and obviously we're going to do pay equity evaluation at that time, but now you scared me about inheriting some past issues. Have you seen any legislation or any lawsuits around that? Like, how worried should we be about inheriting mistakes in the past?
So, good question. So claims under Title VII, you have 180 days to make your claim, and then what Lilly Ledbetter says is that each of those paychecks, is a new wrong. But if you get past your 180 days, you're relatively safe from that perspective. 2 years is kind of your window for Equal Pay Act claims, and so that would be, the range that you would want to look back as you're doing your analysis with respect to whether there were mistakes that had been made or errors that had occurred, prior to the time that you took over the organization. Some of that can be negotiated in the acquisition as far as what you're taking on, or what sort of responsibility or liability is going to stay with the prior organization versus what you're going to take on, and then obviously think about the insurance side of it too. But I do think it's worth considering and worth doing some analysis, not just in the exact moment of sort of acquisition date when we're going to take over, but also looking back probably 2 years at what we've done historically.
Thank you very much.
For sure. Final questions?
I think one over.
So let's say hypothetically, we have one remote employee in Colorado.
Hypothetically.
Not anymore.
How much, and maybe we can talk later on, but would we need to consider when posting, positions for our main office state and still be compliant?
So if you're hiring in a job that cannot be performed in Colorado, if it is going to be performed at your headquarters and there's no way that a Colorado employee would be able to, it's not a remote role, then you do not have to comply with the Colorado laws simply because you have one employee in Colorado. But if it is a remote position that you're hiring for, you are going to have to comply with the Colorado law because presumably a Colorado employee could, or a Colorado individual could take that job. And so it's just going to depend on the specific role and whether or not it's an in-person position or remote.
Okay. And how about on pay transparency? Would we need to, because right now the state I'm in, it's not required, but obviously Colorado is different. So
Yeah, so if it is a remote position capable of being performed in Colorado, then you would have to include all of those pay transparency, the salary ranges, all of that would have to be included in the job posting. If presumably a Colorado employee could take the job, but if it is just because you have that one employee in Colorado doesn't mean you automatically have to comply. If it's a in-person position out of state, then you do not have to comply with the job posting salary range requirements.
thank you.
Any others?
Okay, so I'm asking for a friend.
Got it.
What? Hiring an executive from a competitor who's got golden handcuffs and incredible long-term incentives that my friend's current packages don't include. So we're trying to get this person on, my friend is trying to get this person on board and using some deferred bonuses as a strategy, 1 year out, 2 years out, 3 years out. My friend has done this for other executives in recent years, but not for all executives. So sounds like I need to call our employment attorney about this.
I think that's probably the short, correct answer. Different executives may justify, different executives in different roles may justify different packages. And there is the market piece that we talked about too, and we can kind of think about that and try to figure out a good justification for those changes. I think that higher executive level positions are harder, right? Because there's more variation in my experience in what compensation looks like at the C-suite level within our organizations. So if we have a CFO and a CEO who have different packages, that's okay. They're doing different jobs. I just got a demand letter from a creative plaintiff's attorney recently who said, wait a second, and this I thought was kind of interesting. The severance offer that you gave to the CEO who was being exited during an acquisition was different than the severance package that you offered to the CFO during that exit, and that's discrimination. And the Equal Pay Act actually does say, when they talk about wages under the Equal Pay Act, it means all those things. It means benefits, it means salary, it means bonuses, it means each of those different things, and it means severance. There's actually case law out there, I learned about it when I got this demand letter, that says that means severance too. And I said, but wait a second, CEOs and CFOs are not the same. And he's like, I know, but it was the best I had. He just sort of admitted that it wasn't a great argument. So different executives may justify different packages. The beauty, if you want to think about it that way from an executive standpoint, is that we don't often have two CFOs, right? Or two chief operations officers. And so there may be reasons why people are compensated differently. But I do think if you're hiring for very similar roles, and especially if the money's really different, it's probably worth having a conversation with your employment attorney and getting to the bottom of it.
And
What if they're in the same grade? Like if your CFO and your COO were in the same grade, then would they need substantially the same?
Good
severance
question. I mean,
package?
so they should be in the same grade, right? So the same salary range, but oftentimes we have people in the same grade that are at different places within that range. If we're going to be way outside of that range, that's probably something that we'd want to just think through and talk through a strategy on, and maybe provide some justification either in the employment agreement or within our documentation otherwise to ensure that somebody's Severance packages theoretically would be treated just like any other category of compensation.
And benefits then, so SERPs, you couldn't have a SERP for one in the same grade and then someone else.
And so I've had a case where it was a CEO said, I'm a female CEO. The previous two CEOs had different packages. But when you look at them combined, her base salary was higher, but they had massive stock options and they had different bonus plans. And so it's considering those all as a whole. And so let's say her salary may be less, but she has a lot more stock options. And so I think you can't just look at like one component apples to apples. It's the full compensation package that are going to be considered as a part of those.
Yeah, and I do think grade would be one factor that a court would look at as to whether two positions are substantially similar, substantially equal. But I think our argument would be, yeah, they're both grade, 20, but this person requires this kind of degree, this person has this much experience, this is what their role is with the organization. And so I think we'd sort of try to overcome that grade level issue and say that's just one factor and there's all these other factors that justify different compensation, if that's the conclusion we want to reach. I think we're close on time. Any final questions? Well, we sure appreciate your time and attention and the opportunity to be here with you all today. Thank you very much.